Yes, counsel. Good morning.
May it please the court, good morning, Your Honors. I am Peter Onick for Joshua Lewis. Your Honors, the appeals court correctly described the prosecutor's closing argument as grossly improper, but the court was mistaken in concluding that the prosecutor's errors were not prejudicial on the ground that the evidence against Lewis was overwhelming. The appeals court failed to mention three significant aspects of this case which indicate that the evidence was not overwhelming. First, the medical records show that Trooper Demos's final shot, the one that broke Lewis's leg, entered his body through his buttock from behind, a fact that directly contradicted the trooper's testimony that he fired that shot as Lewis was facing him squarely. Second, although Lewis was not wearing gloves during the incident, forensic testing of the Colt firearm failed to detect any fingerprints, even partial ones, on any part of the gun.
But that's not so unusual, is it?
I think that is a very odd fact, Your Honor, that there should be not a single ridge, not a single line, not any partial fingerprint. We're not talking about a full individualization. The Commonwealth witness, in fact, mentioned that 3 to 6% of analyses of guns, fingerprint analyses, in only 3 to 6% is a quote individualization made.
Oh, but your point is that that's very different from having nothing at all.
Nothing, not a single ridge, not anything. How odd?
Think of that though, because this was the gun, according to Foe, that Foe had on his person, correct?
That's right.
So if it's nothing there, then it also means nothing from Foe, nothing from the police officer. So what inference are you suggesting we draw from the absence of fingerprints?
It is hard to explain. How could it be that if one or more people could have handled this gun, necessarily, somebody had to have handled this gun? There are no...
I'm guessing that the police at some point wiped it because to support your argument that they carried it over and then to get rid of the evidence?
I think that is a possibility. How else to explain the absence of all fingerprint, of any manifestation of a fingerprint on a gun? On a warm day, this was a July evening, 6 p.m. in July, a nice day, light out, warm weather. How to explain that? It is a mystery. It is one of several mysteries in this case. I'll offer the third significant aspect of this case, Your Honors, which is mentioned nowhere in the appeals court decision. The jurors deliberated for parts of 3 days, a full day in the middle, 6 or more hours on the third day. We don't know exactly how many hours on the first day. I calculate conservatively, it must have been at least 12, 14 hours. It's hard to tally precisely, but it had to have been many hours, certainly conservatively no fewer than 12 hours. And they sent a question to the judge indicating that they were having difficulty reaching their verdicts. They said, what happens if we're unable to reach a verdict on one or more counts? This was toward the end of the second day, which was the full day. So that already after many hours of deliberation, they were struggling. So from the juror's point of view, the evidence was not overwhelming.
Yeah, let me stop you there. On Record Appendix page 22, it says, judge's answer, you must continue to deliberate.
Yes.
Was that all that the jury heard, or did the judge explain what a hung jury may be, or simply hand back this note with that answer?
I think that was the answer, Your Honor. I can't answer. I don't know absolutely with certainty, but I believe that that was the answer, the written.
And was there any objection to that answer?
I don't believe so. I don't believe so.
But just following up on that, in the transcript, there's nothing to suggest that she gave some kind of Rodriguez charge or anything?
No, certainly nothing like to a Rodriguez charge.
Was there discussion with the lawyers about how to answer the question?
I cannot answer that now, Your Honor.
But was there some discussion with the lawyers that suggested that we got to do something because the jury is deadlocked?
I don't know whether there was discussion before the judge wrote that answer on that note.
Okay.
And was there any discussion about the answer being wrong? I mean,
No.
that's not true. I mean, the question was, what happens if we're unable to reach a verdict on one or more counts? And the judge's answer is, you must continue to deliberate. Well, as a matter of law, that's actually not correct. If the jury is unable to reach a verdict, then
Yes.
they're entitled to, and that's a hung jury.
Right.
That's why I'm asking whether there was any objection or any discussion with the
No,
jury.
there was
about
not.
this.
And there was no discussion as to whether the jury by that point had done enough deliberating that we're now counting the number of times that they're announcing.
Right, I'm not necessarily suggesting that this is a question indicating that they're hung. It's just it's the answer that says you must continue to deliberate, even arguably, even if you're unable to reach a verdict.
Right. None of those things happened. Discussion of whether this is getting to that point where we're going to begin to scrutinize very closely whether this is a jury that may just have to be sent home or not, or whether a true Rodriguez charge will have to be given. It didn't reach that point. But my point is that this is not a jury which is accepting as overwhelming the evidence in the Commonwealth's case. They're going to come back for a third day, and it will have been many hours of deliberation before they finally make their decision. And the appeals court says that this is not prejudicial error because the evidence is overwhelming. This is not overwhelming evidence. We have these three items that I mentioned, that none of which is mentioned in the appeals court decision, by the way, where they're tallying up their factors. The shot in the buttock, the whole denouement of the trooper's story is that at the critical moment, Joshua Lewis has turned fully squarely facing me, the trooper said, pointing his gun at me, and that's when I shot the third shot that broke the leg, and Lewis fell. Well, the medical records say that shot entered Lewis's buttock. He was shot from behind. He was not squarely facing that trooper. We have multiple records in the Commonwealth's brief as well. Left buttock, bullet hole in left buttock.
How do we know that was the final shot?
The trooper himself said that's the final shot.
The one that shot him but he didn't say it was because it was the one that shot him in the buttock.
No, he says he shot him facing him squarely.
Well, he did. Weren't there some shots that entered?
Yes, the first two shots struck Lewis at the top of the hip, right where it's an abdominal wound where the abdomen meets the top of the hip. And then in the elbow right there as well. So two shots in a very close range on the right side.
And does the trooper testify, or is there evidence that those were indeed the first two shots?
Yes, I don't think there's any doubt from the record that those are the first two shots. Then there's a pause. And Lewis speaks, and this gets to the other issue, the required finding issue as to the intent to kill. Lewis speaks for the first time. He speaks and he says, "You shot me." So there's a little pause. "You shot me." And then, now the stories diverge there. That is, the trooper's story diverges from the medical record. The trooper says that after saying "you shot me," Lewis then fully turns squarely to face him and points the gun at him. The medical record says that what happened then was a shot entered Lewis's buttock and traveled through and shattered his femur. That's why it broke the leg bone. It traveled through the buttock to the upper part of the femur, shattering the femur, and that's why Lewis fell. So what to make of this impeachment?
Did anyone ask the police officer about the inconsistency on that point?
No, I don't believe so. If so, well, again, Your Honor, I can't vouch. It's a law. It's a substantial transcript. I can't vouch for that for sure. But that's the trooper's story. That's the denouement of the story. The justification for what he did, says the troopers, that my client.
You're not. Just to go back to Justice Ireland's questions, you're not arguing that somehow counsel was ineffective for not pursuing that. You're arguing that it was a close case, and therefore the closing argument of the prosecutor was prejudicial.
Yes.
Right. That's
Yes.
what you're arguing.
And what I'm doing is I'm showing substantial areas of impeachment of the Commonwealth's case, which shows that this was hardly overwhelming evidence. We have the impeachment of the trooper as to that final shot, because the medical record says that Lewis was shot from behind. And we have the lack of all fingerprints. I think in odd fact, not a single shred, not a single ridge detail, nothing at all. What is that about? And there's other impeachment too. There's the fact that Demas's first-person narrative, his police report, turns out to have been written by someone else.
What was the evidence that the defendant had a gun?
The evidence that the defendant had a gun is simply
Carrying a firearm.
is the trooper's testimony.
That's it. That's it. Trooper's testimony is the only evidence that the defendant had a gun?
Well, and one of the three civilian eyewitnesses. There were three civilian eyewitnesses in the parking lot. This happens in the parking lot in front of a Panera restaurant and other commercial establishments. There are many people around, many cars around. It was a nice July evening. The three witnesses say they saw the actual chase, different aspects of the chase and the.
But did they see a gun in his hand?
One says, DiNapoli, the witness, Dennis DiNapoli, says he saw a gun. The other two do not say they saw a gun. They saw people running and whatever, but no gun. So one other person sees a gun.
Did trial counsel argue to the jury that the trooper couldn't be believed because the medical evidence indicates that Lewis had been shot in the buttock?
I don't believe that the trooper was directly challenged with that.
No. Was he? No, I don't mean in cross-examination. I mean in closing argument.
Oh, yes, certainly.
The trial counsel argued that point in closing.
Yes. And, it's interesting because just on rereading the prosecutor's argument yesterday, page 22 of the prosecutor's argument, which is in a volume that's labeled November 25th. It should be October 25th. So it's the one that says November 25th. I believe that the prosecutor does an odd thing, and you'll reach your own conclusion. But the prosecutor says, well, I'm going to respond to that. And the prosecutor says, well, these first two shots hit him right around here, and they spun him around. And that's why the third shot may have gone in his buttock. Okay. But that seems to be an abandonment of the trooper. The trooper is saying, I shot him when he was squarely facing me. You see? I mean,
the shooting when squarely facing is the only evidence of assault with intent, right?
Yes. The assault with intent to murder is based on the allegation that Lewis reached in his pocket as he was running, drew out a gun, and was turning as this frantic race through the parking lot occurred, and was shot. He hadn't quite turned all the way toward the trooper, according to the trooper, when the first two shots were fired by the trooper that hit Lewis here and in the elbow. And then after those shots are fired, Lewis says, you shot me, and then turns fully to face the trooper, pointing the gun, and the trooper says that's when he shoots him. Now, but the interesting thing is on page 22, the prosecutor says, well, those two shots spun him around. Well,
what prompted the prosecutor to make those comments?
The defense counsel's closing argument, which says, what about the shot in the buttock? How do you explain that, jurors? This isn't overwhelming evidence. This is a strong challenge to the credibility of the trooper. That's really the focus of the defense is a challenge to Trooper Demas's story about what happened.
And speaking of that, with regard to the closing argument, should we be a little bit more gentle with a prosecutor when the claim essentially is that there was a planted gun, a very, very serious charge of misconduct against the police officer? Should that provide a prosecutor with some greater leeway in terms of speaking about the case?
I don't think so, Your Honor. I must respectfully suggest no. Things happen. Troopers make decisions, like all of us. This is the theory of defense, that this is what happened, that Mr. Lewis...
But the theory of defense here essentially was obstruction of justice. It's quite a serious allegation.
It is very serious. But, you know, I'm as you speak, I'm mindful of the Murchison case. The Murchison case, I'm sorry, I didn't expect that question, so I don't, but the Murchison is a case where there, I believe at trial there was an effort to thwart defense counsel's effort to make an argument like that. Perhaps it was a closing argument or whatever it was. In other words, you know, it's inappropriate to suggest the police may be lying or whatever. This court said, no, that's a defense. Sometimes police don't tell the truth or change their stories or whatever. The facts will play out as they will. And it was inappropriate to limit the defense to suggest that if the defendant cannot suggest that the police have acted inappropriately in this way. That is the defense. Murchison is the case.
Your time is up.
Okay. Thank you very much, Your Honors. I rest on the brief as to the other issues, of course. Thank you.
Good morning, Your Honors. My name is Marguerite Grant. I'm an Assistant District Attorney in Norfolk County representing the Commonwealth. The trial prosecutor, Robert Nelson, is not with me today. He is no longer an Assistant District Attorney. I want to start by saying that the trial prosecutor said several things in closing that were absolutely inappropriate. However, the trial judge did not abuse her discretion in denying a mistrial, which is the only remedy that defense counsel asked for. And I would suggest that the reason that's the only remedy that defense counsel asked for is because of things that defense counsel himself said that were misstatements of the fact in closing. I'm not arguing that the prosecutor is entitled to fight fire with fire. I'm simply pointing out that this judge was handicapped in what she could do. And if I could turn back time and...
The judge was handicapped? The judge couldn't have given the jury some very specific instructions about these obviously improper comments? The judge couldn't do that?
As explained at footnote 15 of Kozak, the judge did not have the opportunity for a leisurely review of the transcripts. She was faced with a situation where the trial prosecutor did not object at all to defense counsel's closing, though he should have. And defense counsel waited until the end of the prosecutor's closing to object. And then when he did object, a lot of his objections kind of missed the mark. He argued that it was improper for the prosecutor to say that defense witnesses lied. That's not right. He argued that it was improper for the prosecutor to not say, I suggest, every time he argued an inference, when the prosecutor did say, I suggest, quite a lot. So a lot of the objections the defense attorney did make missed the mark. So the judge wasn't given the benefit of either a transcript or even two lawyers squarely putting before her, this is what the evidence said, no, this is what the evidence said.
Specific objection to the point about when the prosecutor impugned the defense counsel's integrity, and wasn't there a specific objection about that?
Yes, there was. And I'm not condoning that statement when the prosecutor...
But the judge didn't deal with that, correct?
She did argue, she did instruct that you were not to take the evidence from the lawyers, and the prosecutor himself said, what I say the evidence is doesn't matter.
The decision, I'm sorry, I'm just reading the appeals court decision. Although the defendant objected to each of the improper statements, the judge declined to give specific and contemporaneous curative instructions.
Right.
You're saying that's wrong.
Well, he objected, and in his description of why he was objecting, some of his comments really missed the mark. To say that it's improper for a prosecutor to argue that a defense witness is lying. What the prosecutor said is, the lies here came from this table, and I'm not leaving out the defense attorney. I'm not saying that's proper, but I don't think it rises to the level of a case like Grandison, where the prosecutor said something like, it's outrageous for the defense to cast aspersions on the credibility of the police. It's not like that. It's closer to the recent cases in my 16L letter with the Monday morning quarterback and the lawyer with the office in New Hampshire. That's Ortiz and Scott. And also to Raposa, where the prosecutor said, oh, this defense attorney can spin gold into straw. Commenting on a defense tactic is proper. Saying that a defense witness lied is proper. Where the prosecutor crossed the line here is the prosecutor, as he said to the judge at sidebar after his closing, the prosecutor was of the view that the defense attorney had knowingly called Foe to falsely testify.
Well, based on what?
Well, based on the inconsistencies between Foe's testimony and Lee's testimony.
It's a serious charge.
It is a serious charge.
Very serious charge.
And it's one that the prosecutor should have brought to the judge's attention and not dealt with it himself in closing argument. But it brings me to part of the reason why the evidence was overwhelming. Lee, the driver of the car, testified that he saw in the side view mirror when the trooper took the gun out of Foe's waistband, and Lee said the gun was black. That's what the trooper said. So it's the black Beretta on Foe, according to Lee. The defendant or Foe at trial would have both guns on Foe. And in addition to which, the other evidence, Mr. DiNapoli, Dennis DiNapoli, the president of the Brockton City Council, was the one who testified that he saw the defendant pull the gun and point it at the trooper. David Delaney testified that he saw the defendant reaching for his pocket, and the trooper said stop, and the defendant was turning to face the trooper. So although Mr. Delaney, as defense counsel argued in closing, his view of the defendant's hand was obstructed by some cars, he did see him reaching for his pocket, he saw him turning, and he heard the trooper say stop. Lisa Bonifacio heard the trooper say stop or I'll shoot.
I'm a little confused by that scenario in light of the medical testimony that he was actually shot in the buttocks, in the back. So what the trooper testifies to is that he turns around, he pulls a gun out, the trooper is hiding, and he's saying, drop the gun, lots going on. I don't know if anybody hears him saying those things, but he says that. He radios all this time, and he says, don't move or I'll kill you. Lots of stuff going on while this guy is slowly turning around, pulling a gun out, pointing it at him. Then he, is that when he shoots him? He shoots him, and then and then the shot guy, who's now a third shot, puts the gun back in his pocket? I don't know how that works.
It's the evidence is that it's when the trooper gets to him, it's halfway in his pocket or out of his pocket.
It says he puts it in his pocket.
Right.
The man he just shot, there's a gun facing him, which he shoots facing him before he falls backwards after facing him.
Right.
Remembers to put a gun in his pocket. The whole thing is very confusing in light of the medical evidence.
Well, what the trooper said was his last shot to the defendant was to the defendant's leg. Whether that is the shot to the buttock as the defendant was spinning from the impact of the first two shots, or whether it was the shot to the right iliac crest as described in the, I don't know. I can't necessarily match up the medical records.
He never testifies that he shot him in the back and the buttock.
The trooper testified he shot him in the leg.
Right.
Whether that means right hip or left buttock, I don't know. But he knew that the last shot took him down because he fell when he shot him in the leg.
Now, is it your position that the evidence is overwhelming as to the charge of assault with intent to murder?
Yes.
But there was still no bullet in the chamber.
But the evidence was that it would have only taken him to manipulate the gun to put the bullet in the chamber. And I'd also call the court's attention to Commonwealth v. Gordon, which is cited as an appeals court case cited in the Commonwealth's brief. In addition to the fact of the defendant pointing the gun loaded with a hollow point bullet at the uniformed state trooper, There's all of the other evidence, including the fact that when the blue lights went on behind them, the defendant and Foe simultaneously said, "Oh, fuck." The fact that there was a smell of marijuana in the car.
So I'm sorry,
That's
that goes to the assault with
Yes.
intent to murder?
Because it goes to the defendant's knowledge that there were drugs and other guns in the car and they were being stopped. It gives him a motive to assault this police officer to get away from being arrested for the drugs and guns that are in the car.
We hear thousands of cases where police officers stop individuals who have guns or drugs in the car. Is the inference that there's a motive to kill in all of those?
If they pull a gun loaded with a hollow point bullet and pointed at a uniformed state trooper, my point is that the totality of the evidence goes to the defendant's intent to kill.
Okay, I guess my question is not whether the evidence is sufficient. My question is whether it's overwhelming, where I understand that it would not take that much to get the bullet in the chamber, but it wasn't.
Well, I would also point out that the appeals court said at page 124 of their opinion that one of the problems with the troopers, with the prosecutors repeatedly referring to the defendant and his friends as thugs, and I'm not saying that's proper, is that the appeals court said that that was imputing Foe's and Lee's past crimes to the defendant. I don't think it was. I think it was imputing their conduct on that day to the defendant, that the information I said a few minutes ago about the smell of the marijuana and what the defendant said when the car was stopped shows that the defendant knew that his co-defendants had drugs and guns on them, or a gun and drugs, and therefore that minimizes the prejudice from the repeated, though improper, use of the term street thugs to describe the defendants. The prosecutor said it 5 times. It was wrong for him to have said it 5 times. If he had only said it once, I might even be arguing that it was not improper. But 5 times is clearly too much. I would also point out that another problem was when the prosecutor argued that the entire defense is a sham. That is not proper under Commonwealth v. McCravey. But I would point out that when he did so, he was referring to Exhibit 26, which is a photograph at page, essay page 27, that depicts a cane. And the prosecutor was entitled to argue, as from the evidence, though it may seem like a stretch to some people, but the evidence was before the jury, and the prosecutor was entitled to argue that that part of the defense was a sham. The problem was in McCravey is that the prosecutor's arguing the entire defense was a sham was not tied to any specific piece of evidence.
Well, you say it was tied to that piece, but I guess I have not read the transcript or the closing argument, but it seemed to me that it was an illustration, but that the comment could certainly be interpreted to mean the whole thing, the whole defense that this gun was that the trooper had, put the gun on.
Well, but under Sylvia, I think the prosecutor's entitled to argue if the defense is going to be the police planted the evidence, the prosecutor is entitled to argue that that's not true, that's a lie. And so the problem that I'm facing is that the court said in McCravey that the words, the entire defense is a sham, should not be uttered. And they said that because the appellate prosecutor conceded that. And the judge, the Supreme Judicial Court actually quoted the appellate prosecutor's oral argument in making that concession. And so there are plenty of other cases, including, Felder, where there was talk about a smoke screen. To have a case that says you cannot use these words based on the appellate prosecutor's concession puts me in a difficult position. But my point is, read in context of the reference to the cane and the reference to the eyeglasses and the references to the defense that the gun was supposedly planted and it was supposedly wiped clean, that is it was not prejudicial, and what the judge did in terms of denying a mistrial was proper in this situation.
If I could turn you to the I'll beat this again statement. I can understand why I'll beat this arguably may be admissible, but why I'll beat this again, which makes reference to having had some event where he was criminally charged and he managed to beat it.
A very vague reference, and it's what he said.
Okay, but the judge, of course, is able to examine probative weight versus prejudice, and did so initially, but still let in not only I'll beat this, but it's the part where I'll beat this again. Doesn't that add a concern that the jury is going to, especially combined with the reference to street thug, that this is a guy who has had prior crimes charged?
Well, there are other cases cited in my brief that talk about when defendants' admissions make vague references, even less vague references than this, to past bad acts. And I think this falls squarely within that. It came in on redirect, or rather in rebuttal.
Which means it was the last thing the jury heard.
Well, but it was aired in a motion in limine, and where the defense raised this defense that supposedly the police planted evidence, I'll beat this again, is an admission that the defendant has a gun. The defense didn't ask the judge to redact the word again.
My point is, apparently what was said was, I'll beat this again. I guess my question is, why not simply say, I'll let in, I'll beat this, but I will not let in, I'll beat this again?
Defense counsel did not ask the judge to strike the word again. And maybe it would have been in the judge's discretion to do so. That issue was not put before her.
Well, the defense counsel did object to the admission of this evidence, correct?
Yes, but did not give that's a brilliant suggestion of a way for the judge to have cut the baby in half. She wasn't given it, and just as she was not given a proposed instruction, as in Williams footnote 9, about exactly what the prosecutor said that was wrong, the problem is she's in a difficult position when the defense attorney makes an objection asking for the moon and then later claims that he wasn't given some more reasonable remedy that he never asked for. It puts the judge in a very difficult position. I see my time is up. I thank you, and I rest of my brief. I would ask that the court affirm the convictions because the evidence here was overwhelming.
Thank you.